Have you been told that if you leave the house, you're going to lose everything? Or that you need every single financial document possible before you can settle your case? Or maybe someone even told you not to bring up any domestic violence in your matter? If so, this episode is for you. Because today we're going to be breaking down some of the worst legal advice that we've heard recently being dished out in family law in Australia. The kind that spreads online and over the back fence and at the school pickup gates. We'll explain where these myths come from and why they're wrong and sometimes dangerous. And we're also going to talk about what the law actually says. So whether you're just starting out on your journey or you're deep up to your neck in property negotiations, this is an episode for you to know how to spot bad legal advice. So hopefully it can save you some stress and some money. Welcome, Mum.
Hello, Laura. Hello, everyone.
Before we get started, I would just like to point out that Mum is not your lawyer. I am not a lawyer. So this is not legal advice. This is a general educational discussion and a warning sign to those people to get actual legal advice and sometimes a second opinion. There will be discussions of family violence. So if you feel triggered by this, please call 13 11 14 Lifeline, or you can call 1300 RESPECT if you need support when dealing with family violence. Let's get to the jingle and let's get started.
Hello, I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Now, Mum, I know we said we were done with rant episodes. And this isn't a rant episode. This is a really good thought out one because we felt it was really important. We've been doing webinars recently and at the Q&As that we've been doing with our members, there's been this common thread of myths that people have been told that are causing them such horrible heartache. Do you want to touch on why you've decided to do this one today?
Yes, they're terrible myths, but if they've been told to a person by their lawyer, those people take it to heart and they go out and live the advice that was given to them. And sometimes that advice is not correct. And the impact it was having on the people's that we've been talking to, Laura, where a lawyer in a throwaway line said something and now there's months of heartache follow.
So I'm just trying to get my head around it before we dive into them. How are lawyers giving this kind of advice to people? Or are they just thinking they're getting this advice and hearing it wrong?
I don't think they're hearing it wrong. I don't think so. Particularly if they're in a situation that they want to change, a lawyer says they can't. So I think, they would have been listening for the get-go to do what they wanted. I think it's like car mechanics or doctors, maybe, or like anyone that you deal with. There are people who are very good at their job and there are people who aren't or not as trained. Not all lawyers are the same. Not all doctors are the same. But people shouldn't be afraid to get a second opinion if they get a dodgy bit of advice that seems wrong. And the law's changing really fast, isn't it, Laura? We've been so busy with the changes to the Family Law Act for children and then for property just a couple ago. Sometimes I think these lawyers maybe aren't getting the training they need. Slag off on them, if you know what I mean.
Yeah. So why is it really important that people make sure that they're not getting the wrong advice? How can it damage someone's family law case or outcome?
Well, I think in some cases they can perhaps do something that makes them lose the children. I think some people are being harmed. I think that some people are in a holding pattern where they're just waiting. Stick it out for a few more years. They're just waiting.
They're in limbo.
All from a line that a lawyer said to them way back when, and maybe it was wrong advice, or maybe they didn't have the whole story, or even at the time the advice might have been okay, but now in your current season when things have happened, their advice might change if you asked them again.
So how many people do you reckon you've spoken to recently where you've heard these things and you've just gone holy moly and had to correct the record?
Think about in the group things we've had as well, I think bordering on 50 people
in the last
out of a few hundred in the last. and they all, their lawyer says.
And we desperately want to do episodes like this so we can grab as many of you as we can and get you out of those situations before it gets worse. So let's get through them with no further ado. But remembering everybody's legal situation is different. This is Australian family law and WA is slightly different again. And it is also not your legal advice. We are talking about this as a general. Please do not make any decisions based on what we say. But if you hear something that sounds contradictory to what you've been told we'll tell you what to do at the end and how to go about it. So let's talk about myth number 1 that we've come across, Mum. If you leave the house, you lose your rights. So you must stay there. No matter how horrible they are, no matter how horrendous this is for you, do not leave the house. Stay there.
I hate that advice. There is absolutely nothing in family law that says that being in the house gives you more rights than not being in the house. If it's part of the property settlement, it's part of the property settlement. So if you're worried they might do something to the house if you leave, there are ways for the court to address that and for your lawyer to address that. It might be a caveat or something like that, depending on your circumstances. Get advice. But sitting in a house waiting for settlement, I would say, probably delays property settlement. As long it's like the other person doesn't feel the need to negotiate. It's like if you're in the house, how are you going to robustly say no to someone who's perhaps been, aggressive, who hasn't? And this is the thing. If you've separated under one roof and the other person won't leave, insisting that they won't leave, then sometimes that's because they are wanting to remain and control you. Sometimes not, but sometimes I suspect their lawyers said, don't leave the house or you'll lose your rights. It's shocking. So there's nothing in family law that says that is the case.
So I think some people, maybe they haven't got legal advice, but they've heard it that, if you leave the house, it's not in your name, you're going to lose your rights to it. So as Mum has just said, in family law, everything goes into the property pool. It's all looked at. You're not going to be left high and dry. So be mindful of that. But I think some people also, they're told, Mum, you have to wait. And we hear this one a few times. You have to wait a year after separation before we can do anything for property. Or you have to wait a year after you've got divorced before you can do. So they're just living together separately, waiting for this imaginary time thing. So can you explain why that's wrong?
It's wrong because in 1983, the court took out the requirement in the 1974-75 Act that you had to wait a year to do property organisation.
Oh, so it was a thing.
Oh, yes.
Okay.
And prior to that, the matrimonial, 1939, you lost everything if you left the house. But geez, guys, it hasn't been the case for what is it, 30, 40 years? It's just not the case.
So you spoke to someone recently, and obviously we're not going to divulge anybody's names or anything, and it's happened a couple of times, you said, where they've just burst into tears when you've said, that's rubbish information. You, of course, can leave the house.
Yeah.
And they've been stuck there for years.
Yeah. Every month probably feels like another year. It's a long time. And the children are in this awful situation. Now, to be fair, a lot of people, I think, are stuck at the moment because in Australia, if anyone's listening outside of Australia, we actually have a housing shortage for people. And so sometimes they simply can't find another place to move into. But very often, more often than I wish, this is what's happening. They are staying under roof, waiting a year because they can't have property settlement. And this lawyer, someone recently indicated to me that they thought you had to be out of the house for a year and they'd been under one roof for a couple of years. So they didn't actually have an out of the date. And so they really feel stuck. I think helpless and stuck. And there's no need for that.
No. So just to be completely clear, if you leave the house, you do not lose your right. You don't have to wait. And a lot of the time, these people are told by their exes who maybe don't want them to leave. They're coming up with little mini excuses as to why you can't get your property settlement. And realistically, the way the world is right now, sure, it's going to be stressful and horrible. But when it comes to, particularly with family violence, Mum, staying in the house when you're going through family violence stuck under one roof, I think when people are in coercive controlling relationships or in family violence relationships, they tend to minimize the danger. I think they tend to minimize, and it's not their fault. It's because it's what they're used to. So they're used to these things happening. No big deal. I've been dealing with it for 15 years. I can deal with it for a little bit longer. Now, trigger warning, I don't want to upset anyone, but Mum, why do you think it's always a better idea to get yourself safe and away if you can than sticking it out for another couple more months or another year or whatever till you sort things out?
If you've got a coercively controlling person and you're sharing a house with them and you want to leave, one of the reasons I think some people stay is, say, they're used to doing what they're told, but also deep inside, they know if they say no, then there's trouble ahead. So they don't want to actually do the thing because deep down, they're scared of what might happen. Rosie, can I just clarify one thing? I don't think any lawyers today tell their clients that they have to wait a year to do property settlement. I think that they often forget to tell that you don't have to wait a year. I think that hangover from that legislation decades ago is in the common myth. And like you said, at the Zoom.
Across the back
fence.
Just
sort of, right. And I think I might tell the lawyers I know, and any of the lawyers who listen to this, please make sure that your clients understand this, that they can start straight away, because they may not ask you. They're sure that they have to wait a year after they separate.
And look, we have a course and we do our course for this reason. So you can educate yourself so you know what questions to ask your lawyer, because you're right, Mum. When you're that upset by whatever's just happening, you go and see a lawyer and you wait for them to tell you the information. You don't really ask that many questions because you don't know what questions to ask. And then you walk out of there. And then I guess there's a lot of unsaidness that's just assumed. There's an assumption you know all these things. But if you don't, there can be a big gap and can cause big boo-boos. So I just want to reiterate for anyone who is afraid as well, like you said, Mum, because they know it's going to start things. They're afraid to press that button to go, no, I'm leaving. Please call 1-800-RESPECT. Get them to help you create a safety plan.
Yes.
And then get yourself out of there as soon as you can. And then once you're out, then you can negotiate your property settlement from a safer, more strategically level playing field, because you're not afraid of what they're going to say to you when you go home that night or the reactions that you're going to get from them. So please, if you've been told if you leave the house, you lose your rights, please understand that's not the case. Myth number 2, Mother.
Right.
You must have every single document before you can settle property. So disclosure and valuations and moving forward with everything. People get stuck in this one like no one's business. This is the second most major big one. Now, again, Mum's not your lawyer, and we're not saying go with wild abandonment and just agree to any number and walk off and just be done with it. Mum, what are you saying about this? You must have every single document is BS.
It is. It's just BS. The Central Practice Direction issued by the court, the changes to the Family Law Act recently make it abundantly clear that the number of documents you get and documents you need have to be proportionate to the property pool. So if you've got a $30,000 property pool, you don't need to see them for the 3 years. You just don't. The court has a guideline of what you should be getting, and the extra stuff often is coming from a lawyer's point of view, because the way that the court is at the moment, the court can make costs orders against the lawyer or against the client. So the lawyers are now in protective mode as well, and they may say, we're not prepared to assist you unless we have every single document from but you don't need it. And really, you only need enough documents to satisfy the Family Law Act in the disclosure that you're required to do. And as long as you have enough information to make an offer or assess whether an offer is a good one or not and accept it if necessary, then that's all the documents you need. So I do feel people are spinning their wheels before they even get to court with this disclosure issue. And a lot of the times, if you ask your lawyers, why do I need that document? Why do we need that? We don't need to show where that money went. And I think a lot of money's wasted on that. We don't need to show what they did with that money. You just need to show they took it out. Right. It's up to them to prove that what they spent it on. And if they don't, then that's taken as wastage under the new legislation. Get the right answer to a question. Have another think about the question you're asking and whether it needs to be asked.
Now, I'm going to just put a little disclaimer here. This is not an excuse, okay, for you to say, I'm not doing disclosure because you're asking for things I don't think you need. It's not an excuse.
No. You've got to give everything.
If they ask, you give it.
Yes.
But what Mum's saying is, I think you're saying is sometimes lawyers want all of the information possible, where all you're saying is sometimes you just need to prove the money's gone. You don't need to prove where it's gone. You just need to prove they took it. And then it's up to them to prove what they did with it.
Right.
That kind of attitude then takes the power back. Same with, I think, with valuations. You've said sometimes instead of chasing and fighting over things, you could just say, okay, if you're not going to give me a valuation, I'm just going to estimate.
Yes.
And leave it up to them. Can you explain that little trick?
So 2 things with businesses. One is that sometimes the lawyers and perhaps every document in and out of the business, their balance sheets, their profit and loss, etc., bank accounts, etc. But if you get all of that, and sometimes it's like pulling teeth, you might not get it. But
it might take 5 months, 6 months, and $20,000 in legal fees.
That's right. Yeah. And you've got it. You can't just show that to the judge. They're going to go, what's that supposed to be? You need it valued. And valuers don't need you to get those documents first. Valuers go in. They look at the relevant documents, and what they're for is they come up with a number, right? And that number you can take to the court as part of the pool. Now, with the valuations, say, I don't know, if there isn't really a business as such, but there are trucks and equipment that the person uses, and you might want to get that valued, and they won't let you, you're able to just estimate. Look, I think this Caterpillar excavator, whatever, like this, and here it is in truck sales or tractor sales, or here it is online. So you can work out the numbers, and I would go through and put the higher end of the value on each of those, and you'll find they'll either accept it and be upset about it, or they might suddenly get it properly valued for you. But I've simply, for more than 12 months, Laura, trying to get a number on the business, all the documents for the business, and in the meantime, first of all, the person who's still operating the business gets very defensive, but also gives them a lot of time to maneuver stuff around. Whereas if you send a valuer in, ask them to value it at the date that the separation became, because that, in my experience, is when all the shenanigans begin. So get them to value it while everything was still sweet between, and then a value today. And the value today goes in your asset list. The difference between that old value and your value today, that's the wastage you can allege, and put that over in as something that they've wasted so that you get a bigger percentage of what's left.
So realistically, be mindful if your lawyer is saying to you, no, we can't go to mediation. No, we can't do anything yet. We still haven't got this one piece of paper from 1972. And you need to say, okay, why do we need that one paper from 1972? And really explore that question, because we are seeing a lot of people stuck in the disclosure phase for years. Yeah. And that is the one that they write, yes, in the chat, I've spent 30,000, 25,000, 10,000, and I'm stuck. Okay.
One way around that, Laura, because the lawyer may be worried that you're not going to get what you should get, or they're going to get in trouble for not all the documents, you may be able to give your lawyer a written indemnity and say, I hereby instruct you not to go looking for these documents. I have sufficient knowledge of our business affairs to know that what we've got is roughly correct. I don't want you to continue with that. And I indemnify you. If it ever comes up and we've missed something, I'll take the blame and I won't be going after you.
Yeah.
I think we could use those a lot more often for lawyers. Keeps them happy and keeps you having some control over the disclosure issues.
And I think it's important for us to say, we're not saying to you, don't do disclosure, don't do your due diligence, don't just walk away with just taking their word for it. We're not saying that.
No.
But we're saying don't get bogged down too much in the detail if you don't need to. Now, myth number 3, don't mention domestic violence.
If you're separated or about to be and you need to get everything finalised and sorted but you don't know what to do next, or you're looking for a way to do your own divorce and settlement without spending thousands of dollars on lawyer, then you already know what you need to do, and that is to sign up and become a member of the DIY Divorce Blueprint. Empower, educate and equip yourself with the legal know-how and the tools you need to get divorced or de facto separated and finally settle. Work through this course at your own pace without feeling confused, lost, scared or overwhelmed of all the family law legal jargon and processes. Let us walk with you through this journey and show you a better way.
Myth number 3. Don't mention domestic violence. Now, we're hearing this a heap as well. And, Mum, there's been new changes to the Family Law Act.
I know.
So can you please explain your thoughts to people who are told to not bring it up in mediation or to not write it in any letters and to not rock the boat, basically, and why that's a mistake?
Well, from 2006 to 2012, the children's part of the Family Law Act talked about a person who is unwilling to support the relationship with the other person and the children. And what they did, like, people didn't want to be seen as the unfriendly parent, right? And so they were crippled, really, in what they could say to the court for fear of it being looked at as them being not willing to support.
The alienating parent.
Alienating parent.
Yeah.
But now the law has changed. It's a long time since 2012. There is still that thing that you don't want to talk too much about family violence in case the court reaches the conclusion that you're not keen on facilitating time, which frankly, if it's been family violence, of course you're not keen. I can say to you, this is not the way it goes now, okay? The law is different. The court has to look at the best interests of the children. There are expanded definitions of family violence, and there is an understanding that 50-50 with the children is pretty well not a lay down misere. And instead of trying to fit, I always thought it was a square peg in a round hole, trying to make the case that parents could co-parent, even when it was obvious to everyone they couldn't, to now it's like, if there's family violence or if there's anything, you tell us. If you don't tell them, the court doesn't know, and you need to say it early on.
I know you've touched on court, Mum, but what about mediation? Because lawyers are saying don't bring it up in mediation. So what's that all about?
You read my mind.
Yeah.
So that was the next thing. Sometimes lawyers are of the view that if you raise these things early on, your chances of getting a settlement, 0, which is ironic, really, because if it is coercive control behaviour, then your ex is winning again. Furthermore, if you don't raise the family violence in the early stages and then you raise it later on, you open the door for their barrister or for even the judge to conclude that it wasn't really a thing. It's a fresh one that you've just come up with after you've been through all the process of mediation. So you've got to do it. You've got to raise it if it's safe to do so. If you're in it, if you're trapped under one roof with the person and you need to get out, tell them anything just to get you safely out, and then you can make it later on. But I worry about people not raising it early. And also, too, a mediator needs to know. I say put it in writing.
Family violence is now considered in the property part of your negotiations too. And can you explain how, just briefly, we've got some great episodes that explain this in full detail, but how family violence, if it's been a factor, can be seen as part of an extra uptick in percentage.
Yeah.
How does this work?
So the family violence component in the new amendments to the Law Act a couple of months ago, reviving in a way the old case of Kennan and Kennan, which was only occasionally applied. And the principle of that and the principle of the changes to the Family Law Act now is that if your contributions were made harder or more onerous as a result of the behaviour of the other person compared to what your contribution, how hard it would have if you were married to a normal human, then you should name that. And if the court finds that there's been family violence, particularly coercive control, but family violence as well, they will, according to the legislation, it's one of the factors they can take into account, and you may get a bigger share of property as a result of the torment that you've been through. And if the court's going to be suspicious and the other side's going to allege that you only raise family violence for the kids and you've never said anything before, think how much harder they're going to go on you in the witness box if you're trying to claim a greater share of the property, but you didn't allege the family violence at the start. I understand it. If anyone's listening and you're just too scared to raise it, you're not safe yet. Wait till you are safe, But
and then that's your explanation.
And put that explanation in your affidavit, because the central practice direction says that none of the things that the court requires you to do should be followed if it puts you in danger.
So my next question in that topic is, we're hearing barristers and experienced lawyers are saying to their clients, don't mention domestic violence in court, that even though there's these changes to property and parenting, we're not seeing it play out in court. It's a waste of your time. Don't bother. What are your thoughts on that?
Do you know why they're not seeing it play out in court? Because they're not getting up on their hind legs and arguing it and bringing it to the attention of the judge. I remember years ago, the judge who addressed a group of family law specialists about spousal maintenance, right? Alimony. And the judge said, do you know, when we have our conferences, we wonder why lawyers don't ask for spousal maintenance.
So their clients are probably saying, I'm running out of money, I need money. And then lawyers aren't still asking for spousal maintenance.
No, because they didn't think that they'd get it. And remember that cushion, if you don't ask, you don't get. Particularly when it's up to us is to robustly pursue our clients' rights under the legislation.
And there are cases coming through that are showing that domestic violence and family violence and coercive control is having an effect on property.
Of course.
So there are cases that are happening. And so if your lawyer is saying that to you, maybe consider seeing another lawyer. And we're going to talk about that in a minute. Okay. So myth number 4, Mum, Addbacks aren't a thing anymore.
We're looking at you, the case of Shinohara and Shinohara.
Yes.
So this was an appeal court case. The appeal court has said that you can't put things that have already disappeared or been spent that no longer exist on the balance sheet for what property they've got to divide. But it doesn't mean Addbacks are dead. It just means they're going to be treated in a different way. So if anyone listening to this has Addbacks that they think money that's been wasted.
For example, their ex took 50 grand out of their joint account and just blew it into the wind.
We don't know what it's done.
Yeah.
Well, your Addback is that 50,000.
Yes.
If they argue that they spend it on groceries or whatever, it's up to them to prove it. You just prove as far as the 50 grand going out. Now, it doesn't go on the balance sheet because the court can only order us about things that exist, but that you should have a parallel table of things that they've gotten away with so far and invite the court to balance it that way.
In a percentage
and we had that
way.
Case, and we had the case Shaman and Shaman. And that's subsequent to Shinohara. And in that case, the person had disappeared. He was an accountant. He had loans to his parents, gave money to his brothers, I don't know, did everything to the point that I think there was about 700,000 or more missing from the property pool. What the court did in that case was they gave the wife everything that they could find as a result of his wastage pretty well. And from memory, I think there would have been $400,000 left for him out of the other side of the pool.
Out of all the stuff in hidden.
Yes. And then they hit him with a costs order, which I think would have taken most of that $400,000. So, plus he had to pay his lawyers. So every time someone says Shinohara to you, you say Shaman back to them.
Okay.
But unfortunately, a lot of lawyers have stopped at Shinohara.
Yeah.
So you need to educate listeners.
So Addbacks aren't dead. They're just done in a different way. Okay.
That's right.
Myth number 5. And we've done a whole episode on this, but we thought we'd tack this one on the end. You have to equalise your super. That's how super is dealt with. So, Mum, if someone gets told by their lawyer, which we know is happening still, that all that happens with super is it just gets evened out, what do you say to them about that?
Rubbish.
Okay.
Rubbish. Well, you look at the case of Hickey and Bevan, and that we've been splitting super since the year 2000. And it's only been in the last couple of years I've heard this nonsense about equalising super. So here's the thing. If you're a person on a low income and you've got to get a house or something for to provide for your future, The last thing you want is to take a big chunk of your property settlement as superannuation if you can't access it for years. And the court can make different orders about property and superannuation property is to see in what circumstances you may have even less super and give you more cash. Or if you're a person on a big salary, they might give you less cash, more of the super because they know you can restart.
So basically, because super you can't spend straight away. It's something
No,
you have to
that's
put
right.
away and not touch until you turn a certain age,
Yeah.
like your 70s. Whereas cash, you can spend straight away. So then look at, okay, are you going to be poor and living on the streets until you turn 70 and then get all the money? Because that doesn't seem fair. So you're saying they only look at super and assets, other assets separately for the fact that it's a delayed payment.
Yes, that's right. $1 today is worth a lot more to me than $1 in super.
Yeah.
So if you take 50% of the super as part of your property settlement and you really need the cash, you're selling yourself short.
Yeah.
Okay. And if you're someone who loves your super, you don't have to give your super over. If you like, you can give them, if there's enough property, more of the other property pool. If we don't keep that movement in the superannuation up and down and to vary with the property up and down, then the ability of the court to do what's just and equitable for the people in their current and future then you're kind of taking that away. Now, what worries me is of the people I speak to, and I'll tell you it's in New South Wales and Victoria a lot, it's that's sold to them as though that's the law, and so they have to get less property, and it's not true.
No.
Okay, it's not true. And equalise the super seems to be like a catchy phrase.
Yeah.
Like sometimes they name a drink, a really fancy name, and then suddenly it takes off. So if that's what your lawyer's telling you, have a look at these two cases, Hickey and Bevan, and nothing's changed.
I think the catch there is people walk in, we say, go see a lawyer,
Yes,
find out
we
where you
do.
stand. People walk in, they go see a lawyer, and then the lawyer says, yeah, sure, we'll sort out your property, and then we'll just equalise your super. And they go, okay. And then they walk out. They're not going to know that equalising super is just a load of poppycock. So I think this highlights you need to educate yourself. And I know it's frustrating to think that there are lawyers out there operating that are giving information that's not helping people. So you really need to educate yourself as well as rely on your lawyer. Someone said it so great the other day in one of the Q&As last week or the week before, and they said, basically what we've got to do is project manage our lawyer. And I think that is right. Project managing your lawyer is the best way to and lawyers are probably going to be like, oh, please don't project manage me. But you're going to have to. It's your case. And you're one case of many. And you're not their only case, but it's your whole only life. These myths are proof, I think, that you need to educate yourself. Now, Mum, what should people be doing if they have gotten this kind of information?
I think get a second opinion. In defence of young lawyers, if an older lawyer or a specialist lawyer says about this equalising super, the younger lawyers will probably go along because of the seniority of the other lawyers. So I'm not having shots at them, but where equalising occasionally, very rarely might be appropriate, it's not now. You need to educate yourself, guys. Read some of the cases, find out, what's best for you. And it'll require you to have a look into the future and say, okay, for instance, if I take half the super now, am I going to be 3 years down the track compared to the other person's on the track? You can be pretty sure they will have replaced their super. They've probably bought a house if they've got the money, and you're just sitting there with not enough money to do anything. Particularly now houses are so expensive.
Yeah.
And that brings me to one more point. You need to be your own advocate, really, for the lawyers, because as of a couple of months ago, one of the factors that the court is to take into account is the need for one of you to provide a roof over the children's heads. You're likely to be having the children and you can't afford a house for them, even if you're only having them half the time or whatever, then the court can look at that and go, okay, what does this person need so that in 10 years' time, they're not living in comparative poverty? And so there's a bit more legwork for you to do, but you do need to understand it first and then go and do the work So you can show the court, look, if I get this much, I can keep the house. If I get anything less than this, here's a letter from my broker. That's the max I can borrow. Here are some houses I'm thinking about, and I'd like to be able to buy them. And the court may say, look, you know what, that's a very worthy thing. We'll give you more of the cash.
So you've got to be your own advocate.
Yep.
You've also
and
got
project manager.
Project manager, lawyer, and you've got to educate yourself. And I think just those 5 myths alone, just one of them could trip people up and make them spend thousands and thousands of dollars, really, because they're being told something that's not right.
And misery, Rose.
Yeah.
The misery, Laura, of people sitting in the house.
That's why Mum's been ringing me up going, oh, we've got to do an episode on this. I'm feeling so sorry for these people. And so that's why we've done it. We also have our course open for enrolments. We close doors on the 23rd of November. That's next Wednesday. So we've got a week to enroll. You can go through our online course. You can literally educate yourself on property, go through and do the lessons where Mum and I take you through each part of it. Or you can go through the kids stuff and learn all of that. And through that, knowing that information is going to be so much easier for you to then go to a lawyer and to kind of tell, do they know what they're talking about? And also what questions you need to be asking. And Mum, I think the other thing I want to point out is you need to make sure you've got a lawyer if you are going to push this further and go to court, who is, like you said, going to be willing to ask for these things. Because you say, why are lawyers saying don't mention family violence in court because they haven't seen it happen? And you're saying it's because they're not asking.
Yes.
They're not asking for spousal support. They're not asking for an uptick because of family violence. Some lawyers aren't doing it because they're afraid to ask. But that's the whole point of their job. And if that's what you're entitled to, you shouldn't be afraid to ask for it.
When they changed the children's laws, right, from a presumption of 50-50 to best interests of the children, the Attorney General put out a brochure, remember, and said, we never meant that 50-50 was the starting point, but the lawyers have misinterpreted. And so we're not judges, right?
Yes. Yeah.
And if the availability is there, then they should explore these options with you and with the court. I think some people are able to, even after those Q&As that we've had, they go back to their lawyer with, well, what about this case? What about that? And so there's a kind of you're
managing.
Project managing.
Yeah.
I always thought of it as like the labourer who helps. If someone's tiling, you bring them in and you bring the tiles in and you mix up the cement or whatever. But I think it's a higher role than that. Yeah. You're the one who has to keep your eye on the ultimate aim. Make sure you're not spending so much on lawyers that your property settlement's going to be meaningless.
Yeah. And if you know the information, you are going to have a shorter divorce, property, kids settlement. It's going to be a lot quicker. It's going to be a lot less stressful. And you may not end up having to go to court. And I think even if you aren't going to court, but you're negotiating with your ex, you need to know what you're entitled to and what could be a possibility if you did go to court and have that and ask for it and get it. What's fair? Get what's fair, guys. It's breaking my heart to hear these big myths out there.
One other important thing about educating yourself, it stops you from going after something that isn't a thing in family law, or it stops you going after something where your prospects are very low. And so I think settlements happen when one person lets go of unrealistic hopes, I guess, or ambitions, and where the other person, or sometimes where a person then is otherwise able to prove different things and knows the law.
That's right. I think it's all up to everybody going through this to educate themselves, make sure they're asking for what they're entitled to, make sure they're not letting themselves down for what they are entitled to, and making sure that you are arguing with the facts and you are negotiating within what it actually is. Because again, like those people that are stuck under one roof, they haven't seen a lawyer, they haven't sorted anything out, and they're just trying to come up with something between themselves, being told all these myths. It's just horrible. But anyway, I digress. So, Mum, is there anything that you would embroider on a cushion?
Educate yourself.
Okay. And I think I forgot to ask, if they've gone and asked their lawyer and said, hey, I've heard this thing, here's this case, could you explain to me why you still think it's super splitting? Or can you still explain to me why you think I shouldn't mention my family violence? What should they do then?
Well, I'm hoping that their lawyer will go, oh my goodness, thank you for bringing that to my attention. I'll thoroughly check into that. But unfortunately, some lawyers who see themselves as elevated and handing down advice may get shirty about it. And if they do, there's no room in your family law case for an ego-driven lawyer, right? It doesn't help you. You need someone who, whilst they're in your camp, is able to tell you the hard truths and fight for what you should be able to get and let you know when you can't have stuff. What you don't need is someone who's worried about how they look to the other lawyers, how they look to the judge. Some lawyers don't want to ask for things, I've heard of this and seen it, in case the court says no, and they feel diminished for asking and getting a no. That ego doesn't come into it, guys. Lawyers have to represent their clients fearlessly, okay? And within the law.
Right.
So there.
So there.
So there.
Okay.
If
All
they're
right.
prickly about you questioning things, maybe go and see it.
Get a second opinion.
Mm-hmm.
Thank you, Mum, for clearing up those myths. And I hope if you're listening today, and even if you haven't heard these ones, maybe you can think about how you're going to use your lawyer and think about educating yourself and becoming maybe a project manager so that you can get the best outcome for your settlement and a quick outcome.
Did you want to recap on the 5 again?
We can. So that is, if you leave the house, you lose your rights. That's a myth. If you must get every actual single document ever existence before you can do settlement, that's a myth. Don't mention domestic violence at all. That's a myth. Addbacks aren't a thing anymore. That's a myth. You have to equalise your super when you split it. That's a myth. And what we're telling you to do is go and challenge your lawyer in a respectful way or get a second opinion. And hopefully moving forwards, you can be a great project manager, an educated project manager for your case. All right. Thank you, Mum, for your time. And we will be back here again next week. And don't forget, we'll be actually announcing some lucky person who's written a review to receive a phone call from Mum. So if you haven't written a review or a comment on any of our YouTube, Spotify or Apple, please go do that. That would be great. Actually, if I can ask a favour from everyone, if you are an avid listener, if we've helped you in any way, without even having to write a comment, if you can just tap 5 stars, if you think we're great, only because we've been targeted recently by some men's rights groups. And we're not anti-men, we're not anti-women, we're pro-children, and we're here to educate and help anyone, but we are being targeted. And so we have been given some 1 stars recently. So if you could help us counteract that, and by just giving us 5 stars, or at least a nice review, that will really help, because I am worried we're going to drop off the charts and then we're going to not get to the people who need our help. So I would really appreciate that if you could.
Way of paying forward if you found it helpful. And same on YouTube, Laura, if you're not following, and if you can, rate us, put a comment, thumbs up.
And let us know where you're listening from too. I'd love to know what country or state you're from. If it's safe, let us know. But anyway, thank you so much, Mum, for your time today. Wishing everybody the best of luck. Let us know in the comments on YouTube if you've been told any of these myths. We'd love to hear it on Spotify as well. And we'll see you all back next week. Thanks, Mum.
Thank you, Rosie. Bye-bye, Laura. Bye, everyone.
Bye.
It's always a pleasure.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.